Yes, now visible here. Good one. So over to you.
Yes, sir. Good evening, sir, and to everyone present here. I, Avneet Kaur, volunteer of Samp Initiative and moderator for today's event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Advocates Online National Capacity Building Program on Art of Contract Drafting Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Pattern in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice C.K. M.R. Shah, sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about drafting dynamics, key clauses in partnership, and LLP agreements. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hand. It is a privilege to have with us and honor to introduce Advocate Chirag Vajani, sir. Sir is a company secretary and advocate, High Court of Bombay. Sir holds a master's degree in commerce, enhancing his expertise in the corporate world. Sir is a proud member of both the Bar Council of Maharashtra and Goa and the Institute of Company Secretaries of India, ICSI. His commitment to professional growth is evident through his membership with the ICSI ISA, where Sir is enrolled as a social impact assessor, previously termed as social auditor. Sir's legal practice encompasses a wide range of areas, including corporate litigation, civil disputes, criminal cases, and matrimonial matters. His versatility is further exemplified by his experience in IT related matters, allowing him to tackle legal issues in the digital realm. Sir has also served as a distinguished speaker at both the Bhayandar chapter and the Dombivli chapter of Institute of Company Secretaries of India. His expertise has enlightened audiences on range of topics including legal research, social audit, social stock exchange, and NCLT, drafting and pleadings. Sir not only excels in his professional pursuits but also actively contributes as dedicated volunteer at ICSI. Sir currently serves as an elected member of Managing Committee of the Bhayandar chapter of the Western Indian Regional Council of ICSI for the 2023 to 2024 term and previously held the position of secretary in 2023. His involvement underscores his commitment to the growth of profession and the support of his peers. In addition to his professional and voluntary engagements, Sir has also served as judge for group discussion competitions, debate sessions, and poetry citation competitions at Lohana Vidyarthi Bhavan in Andheri, Mumbai, further showcasing his dedication to foster with us today, sir. Over to you, sir.
First of all, thank you, Amit Kaur. And also, I extend my thanks to Pro Bono India and Sambhav Initiative for providing me this platform so that I can share my knowledge with my colleagues and friends. So, we can start with the session. So, today's topic drafting dynamics, key clauses in partnership, and LLP agreements. My screen is visible to all?
Yes, yes, visible. Yes.
Yeah. So this is the standard disclaimer. Anything shared by me on this platform is purely my view, and it is just for information and educational purpose. Moving on to the next slide. So basic question: what is partnership? Because today's topic talks about agreements of partnership and LLP. So what do you mean by partnership? So during the session, anyone would like to give the answer of the question, they can just reply on the chat. So in order to find out what is partnership, we have to go for we have to check the Partnership Act, Indian Partnership Act 1932, where we can find definition of partnership partner, firm, and firm name. So I will quickly go through this. Partnership is the relation between the person who have agreed to share the profits of a business carried on by all or any of them acting for all. So here the key word is they are sharing the profits of business and it is jointly carried on by them, okay, or any of them acting for all. Why any of them acting for all? Because there can be a sleeping partner and there can be an active partner. Now moving on to the next, person who have entered into partnership with one another are called individually partners and collectively a firm. And the name under which their business is carried on is called the firm name. Now, what is limited liability partnership? In short, we often use as LLP. So, in order to determine what is limited liability partnership, we have to check this definition under the Limited Liability Partnership Act 2008. So, henceforth, whenever I use LLP, it is understood it is a limited liability partnership. So, in order to understand what is limited liability partnership, Section 2N of limited liability partnership means a partnership formed and registered under this act. So, whenever you want to know what is partnership, you can check the Partnership Act. But what is limited liability partnership? It is very short and sweet. Any partnership formed and registered under this act. Which act? Limited Liability Partnership Act 2008. Now here, if you see all the definition, there are foreign limited liability partnership also. Limited liability partnership agreement is also defined under this act. And what is the name of the firm and what can be the name of the firm, that can also be checked here. Why these definitions are important? Because before you go and draft the agreement, you should know that what is the prescribed under the act, which I cannot go beyond. Correct? Now moving on to what is agreement. So anyone would like to answer? So to understand definition of agreement, we must check Indian Contract Act. Okay, you must have gone through this. Pursuant to Section 2E of the Indian Contract Act, agreement means every promise and every set of promises forming the consideration for each other is an agreement. Now these are the various features of the partnership versus limited liability partnership. You should know what is the legal status, whether it is a legal separate legal entity or not, how it is formed, whether registration is compulsory, whether it is optional, governing laws, because whenever you draft any agreement, you should always visit the law, because anything you write beyond the law, it is not acceptable, it is void ab initio. You should know many number of minimum partners required to form partnership or LLP, what is the maximum limit, what is the liability, and so on. So now, why partnership agreements matters? Both partnership means whether it is a normal partnership or whether it is a LLP. So why it is required? First is it lays the foundation of the relationship between the partners. Second, preventing dispute, because anything you noted down, write down in an agreement. What is agreement? It is mutually agreed between the parties, so that there is a clarity of the relation between the parties, and it avoids the confusion between the parties. Legal clarity. So legally, you have drafted everything. It is a legally binding document. It also protects all the partners and provides a framework for resolving any issues. So beyond trust. So it is uh, in every partnership, trust is vital. But whenever you write down all the understanding between the parties, it is always advisable. So even partnerships are not compulsorily required to be registered. You should always go for a partnership agreement. not only for a new partnerships. Whenever you go for a amendment in a partnership, when you require changes in the partnership, you should always have the partnership agreement at your disposal. Now, coming to the main topic of the session, we will try to compare the key clauses between the partnership and LLP. There can be the clauses which are common, which can be interchangeably used, but there can be a major clauses where you have to check whether it is applicable to normal partnership, or while I am drafting the LLP agreements, I have to check the clause and draft it proper. So we will start with the title clause. There is a simple difference. It is a partnership, then partnership agreement of so and so. And if it is a LLP, then limited liability partnership agreement of so and so firm. Now, you must have observed the difference. Messrs A and B Associates is the partnership name, whereas in LLP, Messrs X and Y Solutions LLP. So, in LLP, how you will identify that I am dealing with the limited liability partnership? Their name must end with the word LLP. Okay, it is provided by the Act. So, whenever you draft LLP agreement, title must contain that limited liability partnership agreement of so and so into bracket as per section 23 bracket 4 of LLP Act 2008. Now you will give the introduction that this partnership deed is made on so and so date. This will decide that when you entered into agreement. Now this is the common clause. It is the name and details of partners in both the whether it is a partnership or LLP. You have to draft in the same manner that this is by and between first partner, second partner. You have to give the details of name of the partners, their father's name, their complete residence. If required, you preferably give in the LLP agreement. You can give LP number or DIN number, and in normal partnership, if you want to make it more clear, you can always provide their PAN number, or you can always provide their Aadhaar number, depends upon how comfortable the parties are, so that you can establish the proper identity of the partners. Now, moving on to the next clause. Here it is the definition. So you will say why definition has to be included in the partnership agreements, because on many occasions you will not use the entire statement or word. You will use the only keyword. Like I said, whenever I use LLP, it is a limited liability partnership. So and there must be clauses which may require the further clarity. So better to include definitions in your agreement, depending upon the complexity and the language of the agreement. You can always provide some definitions. Like I have given the example, under partnership you can always say the act and the said act shall mean the Indian Partnership Act 1932. So wherever the reference of act or said act appears in your entire agreement, it is deemed that you are referring to the Indian Partnership Act 1932. Same in the LLP, you whenever the act and the said act shall mean the Limited Liability Partnership Act 2008. Designated partners means the as defined under section 7 of the LLP Act 2008. Now name and legal status. So here you will say the firm shall carry on the business under the name of so and so, that is Messrs A and B Associates. Whereas in LLP, as I said earlier, name should end with the word LLP. Like in the case of private limited, we always use private limited. Public limited, we always use limited. So in LLP, we always, our name should end with the LLP. It is a mandatory requirement under the Act. Next, business activity and place of business. So While moving on to the next uh, agreement, next clause of the agreement, we should always mention the place of business or office of the partnership firm, which is decided by the mutual agreement, and it must be mentioned in the agreement. Example clause is, whereas the partners here to desire to carry on the business of, you have to specify the business activity and place. Whereas in the LLP agreement, you must specify its registered office, because LLP is always registered under the Act. Partnership, it is not necessary that it is a registered one. It cannot be. It can be unregistered also, but LLP, it is always registered one. So it is the mandate requirement whenever you go for the registration of LLP. Registrar want you to give the details of the registered office, so that it can be used for the purpose of its registration as well as legal jurisdiction. So whenever you want to apply for some change in the LLP structure, or registrar want to initiate any uh, action against the LLP, defaulting LLP, the jurisdiction of the registrar will be decided based upon the location of the registered office of the LLP. So this is the must. You must use this registered office address in your LLP agreement. Otherwise, it will not be approved by the registrar. Even in case of the dispute among the partners, this can be a vital point. Now, capital contribution. So, in case of partnership, each partner shall contribute capital in the form of cash or kind. Cash doesn't mean, I am not saying cash means the liquid cash. It can be the bank transfer. It can be uh, transferred via account from the account of the partnership firm. Okay, it need not be equal and is based on mutual agreement. So act doesn't mandate that partnership should be on the equal basis. One partner can bring cash, other can also bring the kind, and it cannot be in the same proportion. It should be always as mutually decided between the partners. Now moving on to the LLP, capital contribution must be declared and valued. So you can see the difference when you are going for the LLP. There are some much restriction, much elaborated version of the capital contribution. Here, capital must be declared and valued. So, like, it can be monetary, it can be tangible, it can be intangible, or it can be in the form of services. Whereas uh, we have seen that in the partnership there is only two kind of capital which you can bring in, only cash or kind. Here you can bring monetary, means cash, tangible, intangible, or services. Now you will say, you will ask, what is intangible, what is tangible, what is services? For example, partner A is bringing some amount of capital in the cash, like monetary. One is bringing some kind, it is tangible. Another is bringing some IP, intellectual property, which is intangible. Okay, and or fourth partner is bringing some service, like he is a professional, he is willing to give the service to the partnership firm. So he is bringing some expertise, you can say. So, clause example can be, the partner shall contribute to the LLP in the following manner: designated partner 1, so and so amount; designated partner 2, so and so amount, as detailed in a schedule 1. So, in schedule 1, you can provide all the contribution they have provided. Now, contribution may be in the form of cash, property, or other benefits as agreed upon and recorded with the registrar. So, here one more necessity is that it should be recorded with the registrar. So, whatever partners are bringing in as a in the form of capital contribution, it should be declared, valued, as well as recorded with the registrar. Now, moving on to the next clause, profit and loss sharing. So, whenever we talk about the partnership, profit and losses are shared as per the agreement. But what if in case partners missed out to quote this, that what is the profit and loss sharing ratio? Then if silent, they are divided equally pursuant to section 13b of the act. Which act? Partnership act. Okay. So your clause example will be the net profit and losses of the partnership shall be divided among the partners in proportion to their respective capital contributions or as otherwise mutually agreed upon and documented in writing. Whereas in LLP, so what is the difference between the profit sharing ratio of partnership and LLP? Nothing much. Both should be explicitly defined in the agreement. If not specified, then it is partnership, then section 13b will come into picture and it will suggest that it is equally divided. And if it is LLP, then it is assumed to be equal, and first schedule of the LLP act uh, will be triggered. So only difference is of the act and reference in the act. Otherwise, you can find that profit and losses are not mentioned, then it is equally distributed. Now, only LLP requires that this must be agreed and filed with the registrar. So, since you are going to file entire LLP agreement with the registrar, why I am always saying that this clause should be declared with the registrar? This clause should be declared with the registrar because if you have not declared this in your LLP agreement, there are chances, 99% chances, the registrar will reject your reject, or it will ask you to resubmit your LLP agreement with the revised clauses, including all these details. So, in order to avoid such scenario, you must be prepared that what is required by registrar. So that much detail, at least that mandatory and statutory details should be provided by you while you are drafting the LLP agreement. Now, right and duties of partners. So all the partners have an equal right to take part in the conduct and management of partnership business unless otherwise mutually agreed. Same, each partner shall have the right to participate in the management of the LLP except as otherwise provided in this agreement or decided by a majority of designated partners. So, in partnership, word catchy word is mutually agreed, whereas in management rights under LLP, decided by the majority of designated partners. So, if you are not aware who are designated partners, you must visit the LLP Act. Designated partners are like active partners, and it must be declared that who should be your designated partner with the register. So, rights and duties of partners. So, in the partnership, decision making and voting. All decisions concerning ordinary business matters shall be decided by majority vote, whereas fundamental changes such as change in business nature, admission of a new partner, or dissolution shall require unanimous consent. In LLP, it is more of the same. Matters of routine business shall be decided by majority of partners, whereas matters such as admission of new partners, amendment to this agreement, or dissolution of the LLP shall require unanimous consent. Now, under rights and duties of partners, another rights is right to access accounts. Under partnership, each partner shall have full and free access to all books and accounts, records of partnership, and may inspect and take copies thereof at any reasonable time. So uh, here, what is the time of inspection? It can be reasonable time. Whereas you go for LLP, right to access books and records is more of the same, but every partner shall have the right to access, inspect, and copy the LLP's books of account and statutory records during normal business hours. So here, catchy word is reasonable time, whereas in LLP, it is a normal business hours. Another clause under rights and duties of partners. So duties of partners is duty of good faith. Partners shall carry on the business to the greatest common advantage and shall be just and faithful to each other. Another duty is to render accounts. Every partner shall render the true accounts and full information of all things affecting the partnership to any partner or their legal representative. Another duty is to duty to indemnify. A partner shall indemnify the firm for losses caused by fraud or willful neglect. So whose fraud and willful neglect? Partners. Now under LLP, duties of partners. So here the reference is given. You can check all the sections when you are drafting your LLP agreement. So number one is fiduciary duty. Every partner of limited LLP shall act in a good faith. So it is a duty of good faith. Similar clause is there. Only the elaborated version under the Act. Another duty is compliance duty. Since you all are aware that LLP must be registered one, there are the compliances which is the company. So this is also duty of the designated partners. Here the word is designated partners. Till now we were using every partner, but compliance is the duty of the designated partners, and they shall ensure that statutory compliance, proper record keeping, and accuracy of information submitted to the regulatory authorities. Now, duty to indemnify. Again, a partner is bound to indemnify the LLP for any loss caused by their fraudulent act, willful misconduct, or unauthorized transaction entered into on behalf of the LLP. Now, only compliance duty is exception where designated partners are liable. Now, this is the liability clause you must include in your agreement, that all partners shall be jointly and severally liable for liability of the firm. Now you know part in the partnership, under Partnership Act, liability is unlimited. Even it can extend to the personal assets of the partners, and that's why uh, limited liability partnership, as suggested by the name, liabilities are limited and limited to the extent of the contribution, like in the case of private limited company or limited companies. So partners have limited liability restricted to their contribution unless fraud is involved. So in case of fraud, this will not be limited. Then this privilege will be revoked. The liability of partner shall be limited to their contribution except in case of willful misconduct. So you can see the major difference, and this is the major difference between the partnership and the LLP as well. Now there is a key difference between the partnership and LLP. Again, you should know all this, because when you are drafting the agreement, you should keep this in your mind. You cannot interchange the clauses between the partnership and LLP when Act mandates you to include certain things. Now moving on to the next clause, it is the admission clause. Admission means admission of partners. So, so once your partnership is formed, there will be changes in the partners status in future. So you have to be little bit visionary, that what will be the changes, how it will be inculcated in my agreement, how the partnership will continue to run. So this clause will decide the uh, this clause will decide how you will add the partner or admit the partner in the partnership firm. So a new partner may be admitted into partnership with the consent of all existing partners. Here the keyword is all existing partners. The term and condition of such admission, including capital contribution, profit and sharing ratio, recorded in a supplemental deed, which shall form part of this partnership deed. So this clause is enabling clause. It gives the power to enter into the supplemental deed, and here the keyword is existing partner, because outgoing partner will not have right to decide that who will stay instead of me, who will be admitted in this partnership. In the LLP, it usually requires consent of all existing partners. So clause will be like a person may be admitted as a new partner of the LLP with the written consent of all existing partners or as otherwise agreed in the writing. The contribution profit sharing ratio of incoming partners shall be specified in the supplementary LLP agreement and filed with the registrar in accordance with the section 22 of the LLP Act. Now here, uh, what is the difference? There it must be recorded in a supplementary LLP agreement and filed with the registrar. Unless and until you file with the registrar, it is of no value. So, after admission, retirement clause. In the normal partnership, any partner may retire from the firm by giving a written notice of so and so days. It is mutually decided. You can keep 15 days, 30 days, depending upon your business and depending upon your partner's view to the other partners or in accordance with the provision of this deed. Upon retirement, retiring partner shall be entitled to receive the balance tending to his or capital account, share of profits, and goodwill valuation, if any, as mutually agreed. The retiring partner shall not be liable for acts of the firm done after the date of retirement, provided a public notice of such retirement is issued as required under Section 72 of Indian Partnership Act. So here you have to issue the public notice under the Partnership Act 1932. Whereas in LLP, a partner may retire from the LLP in accordance with the terms of this agreement by giving not less than 30 days. Here, 30 days prior notice is required. Okay. In the absence of any specific provision, a partner may retire by giving notice as per Section 24 of the LLP Act 2008. The retiring partner shall be entitled to the payment of same balance in his or capital account and accumulated share of profits up to the date of retirement within so and so days of retirement. It can be decided, days can be decided by the partners. A notice of retirement shall be filed with the registrar as required under the LLP Act. So here public notice is not required, but since it is the LLP is the registered entity, you have to file the notice of retirement with the registrar. Now it comes to expulsion. So partner may be expelled for their misconduct, or there are so many grounds. So you in this clause you will decide and define how expulsion should be triggered. A partner may be expelled from the partnership by a unanimous decision of all other partners, excluding the partner concerned. So the partner concerned have no right to vote. Okay, on the grounds of which can what can be grounds: willful misconduct, continuous breach of the partnership deed, or actions detrimental to the firm's business. So earlier we have seen the duties of the partner. So if he is not performing, he or she is not performing duties of the partner, he is acting detrimental to the firm's business, then such expulsion shall be exercised in good faith and the interest of the partnership. The expelled partner shall be entitled to settlement of his or her capital and profit share as per the deed. So it doesn't mean that you do not give anything and you just expel him. Okay, if any recovery is there, you can recover it from him legally. In case of LLP, the partner may be expelled from the LLP by the unanimous decision of the other partner, excluding the partner concerned. So it is so far it is the same. If such partner is found guilty of gross misconduct, commits repeated breach of agreement, acts in a manner detrimental to the LLP's business or reputation, such expansion shall be carried out in good faith and for the benefit of LLP. Okay, so here also expelled partner is entitled to receive contribution, share of profit, date up to the date of expulsion. Now, only the mandatory requirement here is again LLP shall file necessary changes with the registrar. Now, transfer of interest clause. So, when partner is retired or expelled, okay, there will be transfer of his share also. Now, in the transfer of interest clause, no partner shall sale, assign, or mortgage, pledge, or otherwise transfer their share or interest in the partnership voluntarily or involuntarily without the prior written consent of all other partners. Why this clause is there? Because in order to protect the partnership firm. If what if the outgoing partner uh, intend to sell the shares to the competing partnership or competing businesses, or the partners who are not going to who can be anti partners, like who will be once it dues in the partnership, it will result in the harm to the business. So any such transfer, if permitted, shall be subject to the transferee executing a deed of adherence and becoming bound by the terms of this partnership agreement. So all the incoming partners are deemed to be bound by the terms of this partnership agreement, though they are not the original signee to this agreement. In the event of the proposed transfer, the non-transferring partner shall have a right of first refusal to purchase the transferring partner's share on the terms not less favorable than those offered to a third party. Now, here the term is right of first refusal. There is a preemptive rights which we will be dealing in detail in the upcoming slides. So here you can use right of first refusal also. Preemptive rights you can also mention. In LLP, again, there is a prior written consent of all existing partners are required. This should be execution by way of execution of supplementary LLP agreement and filing necessary forms with the registrar. And non-transferring partners shall have preemptive rights. Now, what are rights of first refusal? What is preemptive rights? We will deal in the next slide, and we will reframe these clauses, including both the uh, clauses, both the terms. What is right of first refusal? In short, ROFR. So, a partner who wish to sell their interest can first seek an external buyer and obtain a bona fide offer. Before completing the sale, they must offer the same terms to the existing partners who may choose to purchase instead. So, suppose A wants to sell his partnership share from the A and B associates to X. Okay, so X from X he obtains some quote that for so and so amount he wants to buy his share. Now before selling it to the X, A must offer it to the B, his existing partner. That's see, I am getting so and so amount. If if you want, you can pay me. I am ready to sell it to you. So in this case, partner B has a right of first refusal. So once he refuses that no, I cannot buy or I don't want to buy, then it can be sold to external party or external partner, you can say. So ROFR, right of first refusal, is with whom? Existing partner B. Okay, not retiring partner or outgoing partner. So it features are triggered after a third party offer is received. It is always a bona fide offer which is received by the outgoing partner, then only it can be triggered. And existing partners get a chance to refuse and step in on the same terms. So now example clause is if a partner receives a bona fide written offer from a third party to purchase their interest, such partner shall first offer their interest to the remaining partners on the same terms and conditions. The remaining partner shall have 30 days to accept the offer. If declined, the transferring partner may sell to the third party on identical terms. Now, this is also catchy one. Once uh, existing partner has refused to purchase the shares, then when transferring it to the third party, it should be on the identical terms. If the terms are changed, then again he has to offer it to the existing partner, because there may be adverse terms which is not acceptable to any of the partners. So It cannot be foul play. Like that's why it is used bona fide offer. Okay. Now, what is preemptive rights? So, by definition, it gives existing partners the first opportunity to purchase a partner's share before it is offered to any third party. So, right of first refusal, ROFR is triggered only when it is offered to a third party, whereas preemptive right is triggered well before it is offered to any third party. So, it is the key features are triggered before negotiating with outside parties, and it prevents offering to third parties until all existing partner decline. Okay, so in this case, clause will be a partner intending to transfer their interest shall first offer it in writing to the remaining partners that look, I want to sell my shares. Okay, if anyone is interested, you can give me the offer. The remaining partners shall have 30 days to purchase the interest in proportion to their current holdings. Only if all partners decline can the selling partner offer the interest to third parties, subject to approval of the remaining partners. Now, you can include a preemptive as well as ROFR clause in your agreement of partnership as well as LLP. So here you can say preemptive offer, then external offer and ROFR, and consent and admission. So here, in addition to this both, you can also add that there should be written consent of all partners is mandatory. Okay, if anything, this clause will prevent invalid transfers. Like any purported transfer made without the this clause, following this clause, then it shall be declared void and unenforceable against the partnership and remaining partners. In LLP also, you can use use it in the same manner. So now you will ask whether it is mandated by any act. No, there is no mandatory requirement under the LLP Act or Partnership Act, but it is always advisable to protect the interests of the existing partners. Now we will go to the liability post exit clause. Once once the partner has left from the partnership, it will not end into his liability. So you will be surprised why it will not end his liability, because during the course of business when he was the partner, he must have done such act or some act which later on brought some liability on the partnership firm, or some losses in the monetary or non-monetary losses to the partnership firm, then he should be liable. Or there may be a statutory breach while acting as a partner in the partnership firm. So this clause defines the liability, which is the post exit of retiring or outgoing partner. So clause may be read as a retiring or outgoing partner shall remain liable for all acts of the partnership carried out prior to the retirement exit. The continuing partner shall indemnify the outgoing partner against any liabilities arising from acts conducted after the retirement, provided due no public notice of such retirement has been given as per section 32(3) of the Indian Partnership Act 1932. So, till the public notice is issued, he is liable because he has not exited from the exiting partnership. Now, in LLP, a partner who ceases to be a partner of the LLP shall remain liable for all obligations of the LLP incurred while they were a partner. Okay, here only the requirement is there should be a compliance under section 24 subclause 3 of the LLP Act, and it must be filed with the prescribed notice with the registrar. Okay, so practical difference is ROFR and preemptive rights. So ROFR is timing is it is triggered after third party offer. Preemptive rights triggered before seeking outside buyers. Flexibility, partner can shop around the first. They can take the bona fide offer, and then they can approach the existing partner. In whereas in preemptive right, they must approach the partners first. Now control. ROFR, it is a weaker protection, whereas preemptive right, stronger protection. Use case. It is a more seller friendly. Seller means outgoing partner. It is outgoing it is in favorable condition for the outgoing partner. Whereas preemptive rights are more buyer friendly. Buyer means the existing partner friendly. Now we come to indemnity clause. So, continuing partners hereby jointly and severally agree to indemnify and hold harmless the retiring and outgoing partner from and against any claims, demands, liabilities, costs, expenses that may arise in connection with the partnership business after the effective date of retirement. Such indemnity shall not extend to liabilities obligation incurred by the retiring partner prior to the retirement date or arising out of their willful default. So, this indemnity clause is more like a post-exit liability clause, but their liability is defined. Here, who will indemnify them once they are retired or exited from the partnership? In LLP, more like the same. Only thing is here the existing partner has to duly comply with the cessation procedure under section 24 of the LLP Act and file necessary notices with the registrar. This indemnity shall not cover liability resulting from fraud, wrongful acts, or willful misconduct. So, in any of the partnership, when liabilities are covered when it is during the discharge of their obligation as a partner. Once you enter into the arena of the fraud, misconduct, wrongful acts, or any illegal activity, then this protection will not be applied. Now, banking and financial management clause in partnership shall maintain its bank accounts in the name of firm with such scheduled bank as mutually decided by the partner. All fund of the partnership shall be deposited into account and all withdrawals shall be made only through checks or electronic transfer authorized and signed by any partners as mutually agreed. No partner shall operate a separate bank account for partnership firm or utilize partnership fund for personal purpose. In LLP, shall maintain one or more accounts in the name with such bank as designated by the designated partner. Here, designated partners have the power. All LLP funds shall be deposited in this account. Withdrawals shall require authorization by any designated partner as specified in Schedule so and so. No partner shall operate an individual account for LLP funds or use LLP funds for personal purpose. So, here the major difference is here any partner can operate the partnership account under the partnership act, whereas in LLP designated partners are given the more power. Now, proper accounts, audit, and taxation clause. Proper books of accounts shall be maintained on cash or accrual basis. At the principal place of business, the account shall be balanced, and the statement of profit and loss, along with the balance sheet, shall be prepared as of 31st March every year. So, this all you know, it is a financial year. The account shall be audited annually by chartered accountant mutually appointed by the partners. The partnership shall comply with the all tax laws, including GST, income tax, other statutory filing, with expense borne by the partnership from its funds. In LLP, books of accounts are required to be maintained under Section 34 of the LLP Act. Okay, so you have to always refer Section 34 of the LLP Act. Sir, why it is required to refer sections? Because uh, once you have drafted agreement, it that doesn't mean that every time you blindly use the same section and same everything, because there may be amendment, there may be changes which are required by the act. So it is always preferred that before drafting or at the while you are drafting the agreement, you always refer to the section, so that if any requirements which is there, it is not missed by you when you are drafting the agreement, and it will also safeguard the your partnership firm, whether it is a under partnership act or it is under LLP act. So, a statement of account and solvency. So, here the requirement is solvency, statement of account and solvency shall be prepared. annually within 6 months of the financial year end and filed with the registrar in accordance with the section 34(2). Okay, so it should be filed with the registrar. Apart from the other statutory duty, you have to also file it with the registrar. If applicable under the prescribed rules, the LLP shall also appoint a chartered accountant to conduct an audit of its account. LLP shall ensure timely compliance with all tax obligation under applicable laws. So, all GST, income tax, all the laws are applicable here. Apart from that, you have to also comply with the section 34(2) and file this accounts and solvency with the register. So, next is insurance and risk management clause. So, under partnership, the partnership shall maintain adequate insurance coverage to protect its assets, premises, and employees against risk of loss, damage, liability, and business interruption. Partners shall periodically review the insurance requirement and ensure compliance with statutory insurance obligation, including professional indemnity and employee welfare scheme as applicable. Now, why this clause is very much important in the partnership? It may look like a normal insurance and risk management clause, but since you are aware, partnership has an unlimited liability. So, if you have taken the proper insurance, you have taken the due diligence to minimize your risk, to mitigate your risk, then it will be helpful because in case of unlimited liability, as you are aware, if you are unable to pay off the liability or the debts out of the partnership fund, then it will extend to the personal assets of the partners. So in order to mitigate that risk, this should be partnership in the interest of the partnership as well as the individual partners, that they must have the proper coverage. Now this clause also talks about the periodical review. Why periodical review? Because depending upon the expansion of the business, nature of business, it may happen that at the initial stage, whatever insurance was taken, whatever coverage was taken, may not be sufficient in the future, because as the business grow, manpower grow, then in them risk of the exposure to the liability also eventually grows. So you have to periodically review the insurance requirement and ensure the compliance. Whereas in case of LLP, LLP shall also obtain and maintain adequate insurance coverage for its assets and liabilities, professional indemnity, employee and other business risks. The designated partner shall periodically review the adequacy of insurance policies and take steps to minimize the operational and financial risk. Now you will say, sir, in the partnership there is a unlimited liability. Then it is important. Why it is important? The LLP. Because under LLP, it is admitted fact that liability is limited. But what will happen if your liability increases and your firm is not able to pay? Then eventually you have to go for a dissolution. Okay, so in order to uh, ensure the continuity of business, also you have to take the insurance. Now, intellectual property clause. Now, it may happen that during business, your firm may have created some intellectual property, including but not limited to trademarks, copyrights, patents, or proprietary know-how developed or acquired during the course of the partnership business. It, it shall be owned by collectively by the partnership unless otherwise agreed in the writing. So, a retiring or outgoing partner shall have no independent right or claim over such intellectual property except for their monetary share as determined by upon exit. So, maybe you have branded your goods, maybe you have taken some uh, trademarks, maybe you have taken some copyrights, or you have developed, acquired, or any other case, then once it is brought into the partnership firm, it becomes a property of the partnership, because you are utilizing fund of the partnership to acquire or develop this intellectual property, and therefore no individual retiring or outgoing partner shall have independent right. So this is must, because once it is signed by all the partners, outgoing partner, retiring partner, or the partner expelled by the partnership will not create any legal problem for the existing partnership firm. So there are chances that he may outgoing partner may start his own business and may try to attempt to use your existing intellectual property. This will be handy to protect your rights. And in LLP also, any intellectual property created, developed or acquired by the LLP or by any partner in the course of LLP business shall be exclusive property of the LLP. Existing partner shall have no independent right to claim such intellectual property except for their monetary entitlement as determined upon the cessation. Okay, so in case any partners has developed IP during his course of business, then he may have the monetary entitlement as well upon his cessation. Now next, documentation and record clause. So where you will keep all the books of accounts, you have to put this clause to make sure that proper books of accounts and records are maintained at that place. All documents, records and books of under partnership, all documents, records, books of accounts and agreements related to partnership shall be jointly owned by the partners and shall remain in the custody of the managing partner or any other partner authorized by mutual consent. So here you can give the power to the partners or managing partner, okay, so that for giving the custody of the books of upon retirement, dissolution or reconstitution of the partnership, copies of all necessary documents shall be provided to the outgoing partner and original shall remain with the continuing partners or as mutually decided. Now, why outgoing partner require all the necessary documents of the partnership? Because to safeguard is the interest to determine his liability, existing liability. Because once he is out from the partnership, his liability, uh, post exit liability stops there. So he should have the proper access till the his tenure with the partnership firm. Now, what is the difference in the LLP? Here, all statutory records, agreements, filing, and books of accounts of LLP shall be maintained at the registered office of the LLP under the custody of the designated partner. So, here the act is much clear. Okay, where it should be maintained? It should be maintained at the registered office of the LLP, and it should be under the custody of the designated partners. Now, any outgoing partner shall be entitled to receive copies of such document relevant to the period of their partnership without retaining any originals. So this clause is the same in the partnership also, in LLP also. Now next, the LLP shall ensure proper documentation and filing with the registrar as per the provision of 34, 35 and 60 of the LLP Act. Okay, so here the compliance comes into picture. As always, register comes into the picture and you have to comply with it. So it is favorable if you put this clause, these sections you refer in the agreement, so that even the partners will know what is their duties and liabilities. Understood? So this is the major difference: admission, retirement, expulsion of partnership. In the admission of partners, you can see the sections under the Partnership Act and LLP Act: retirement, expulsion, liability and documentation. Maybe we'll share this with you later on. Now we'll moving on to the next clause. It is a dispute resolution. So when there are people, there are partnership, there is a business, there are transactions, there is a chances of dispute also. So how to deal with this? You can put a common clause whether it is a partnership or LLP. Dispute can be dealt with in the same manner, as because under no act it is mandated to put anything. So you can put the steps, like first it will be it will be by negotiation. So any dispute, controversy or claim arising out of or relating to this agreement, including its validity, interpretation, performance, breach or termination, shall be resolved through the following mechanism. First is negotiation. Now you will ask, why this dispute resolution clause is important? Because In absence of this clause, any partner will go directly to the court. There will be a litigation. So if you have the chances to mitigate the litigation, to minimize the risk of litigation, because it is also time consuming as well as financially troublesome for the partnership firm. It affects the goodwill and the business of the firm. So it is always advisable that you devise a mechanism so that dispute can be resolved language, common language, national language, anything you can put, and it shall be concluded within the 30 days unless otherwise mutually extended in writing. Now, what if the mediation, negotiation doesn't work? Then we go for the arbitration. In case mediation also fails, the dispute shall be finally settled through arbitration in accordance with the Arbitration Act as amended from time to time. So you should also know what is Arbitration Act, what are the clauses, how arbitration takes place before you put all this in the clause. Here also you can decide the seat and venue of the arbitration like it is also jurisdiction clause. You can also select the language, and the award rendered by the arbitrator shall be final and binding to all parties, and the cost of arbitration shall be borne as determined in the arbitral award. What if the arbitration is also challenged? The parties agree that arbitral award shall be enforceable in a court of competent jurisdiction having territorial jurisdiction over the registered office, place of business of the partnership or LLP. So, if it is a partnership and not registered one, you can take the place of business as the jurisdiction. If it is the LLP, then it is always a registered office. As we have discussed in the earlier slides, that registered office address is always used for the uh, purpose of jurisdiction. Now, what will be the, because we have used the word notices, we have to exchange the notices to convey our intention to enter into mediation, negotiation, or arbitration. Then all notices or communication under this agreement shall be in writing and deemed duly served if delivered by hand or with acknowledgement by registered post, speed post, by courier, or by email with confirmation of receipt. Okay, confirmation of receipt is always important in any legal notice. All such notice shall be sent to the respective parties at their addresses, including email address specified in the title of the clause of this agreement. So it is the duty of the partners also, if they, in case they, in future they change their address, they have to notify to partnership firm any changes in their addresses so that proper notice can be served. Now, partnership agreement, how it will be dissolved. So there can be a dissolution clause in the partnership agreement, that the partnership may be dissolved under the following circumstances. First is the mutual agreement. Partners may dissolve the partnership at any time through a written mutual agreement signed by all partners. Second is expiry of or completion. There can be a fixed term of a partnership firm based on the project. If, for example, they have taken the project of metro, they have completed the metro. Now partnership can dissolve if there is a time specific. or the project specific. It can be like for next 3 years we'll continue with this partnership, or till we have built this metro, or we have constructed this building, we are entering into partnership for that purpose only. Then it is a expiry or completion. Third is compulsory dissolution. Partnership shall stand dissolved upon the happening of events prescribed under Section 42 of Indian Partnership Act 1932, including insolvency of all partners or the business becoming unlawful. So there may be chances that what is lawful today may be declared unlawful tomorrow, or partnership is becoming unlawful for some other reason. Fourth is court intervention. If any partner may seek dissolution by a court of competent jurisdiction under Section 44 of the Act. So that's why I am emphasizing that you should know the Act entirely, at least the main clauses which are dealing, which you have to deal with when you are drafting the partnership agreement. So, what are the grounds under Section 44? You should know, like incapacity, misconduct, persistent breach of agreement, or other justifiable reasons. Fifth is winding up. Upon dissolution, the affairs of the partnership shall be wound up as per the Section 48 of the Act. All assets shall be realized, liabilities discharged, and any surplus shall be distributed among the partners in accordance with their respective capital contribution or as otherwise agreed. Now we are coming to the dissolution clause of LLP. So it is a winding up clause. LLP may be wound up and dissolved in the following manner. First is following circumstances. First one is voluntary winding up. The parties may decide to wind up the LLP by passing a resolution approved by at least three-fourths of the partners, followed by compliance with the provision of Section 63 and 64 of the Act, and rules. There are rules which are made under the Act. You have to always refer the rules also. Compulsory winding up. The LLP may be compulsorily wound up by the tribunal on grounds specified under Section 64 of the LLP Act 2008, including inability to pay debts, acting against the sovereignty or integrity of India, or persistent default in filing statement and returns. So these are the grounds. So you may visit the Section 64 for elaborated version. Winding up procedure. Upon commencement of winding up, liquidator shall be appointed to realize the assets of the LLP, discharge its liability, distribute any remaining surplus among the partners in accordance with their partnership profit sharing ratio or otherwise agreed. And now it is final dissolution. Upon completion of the winding up, LLP shall file an application with the registrar for striking of its name from the register, after which the LLP shall stand dissolved. So, registrar is there from right from the registration till the final dissolution. So, during the entire journey of LLP, you cannot keep registrar blind. You always have to inform them. You have to keep them in loop during entire the entire journey of the LLP. Now, partnership agreement reconstitution clause, because once new partner is admitted, or other partner is retired or expelled, then there will be a reconstitution of partnership. So in that case, this clause will come into picture. The partnership shall not stand dissolved merely by reason of the death, retirement, or expulsion or insolvency of any partner. So insolvency of any partner, if all partner becomes insolvent, it becomes it triggering the dissolution of the partnership. In such event, the remaining partners may, by mutual written agreement, continue the business of the partnership along with the legal representative of the deceased partner, or by admitting a new partner in place of the outgoing partner. The reconstituted partnership shall execute supplementary partnership deed specifying the revised terms and conditions, including change in capital contribution, profit sharing ratio, and management rights, which shall be duly registered if applicable, and public notice of such reconstitution shall be given as required under Section 63 of Indian Partnership Act. So if it is a registered partnership, then it should be registered with the registrar. Now, under LLP agreement, reconstitution clause will read like the cessation, death, retirement, expulsion of insolvency of any partner shall not result in dissolution of the LLP. The remaining partner may continue the LLP business by admitting a new partner or redistributing the profit sharing ratio. If they are not admitting the partner, then if there is a sufficient number of partner to carry on the show, it not going below the minimum requirement, then they can redistribute the profit sharing ratio, because as you are aware, two partners are required. If after two partner, one is outgoing or because of death or other retirement or expulsion, then mandatory you have to appoint the other partner, new partner in his place. But in case there are sufficient number of partners, you don't want to admit a new partner, then there will be a redistribution of the profit sharing ratio among themselves, subject to necessary filings with the registrar under the LLP Act. A supplementary LLP Act. Now you have to also file the supplementary agreement with the registrar. So supplementary LLP agreement shall be executed by the continuing and incoming partners to reflect the revised terms of management, capital contribution, and other relevant provisions. This is the survival clause. This is the standard clause you can use interchangeably between the partnership and LLP agreement, that notwithstanding the termination, dissolution, or reconciliation of this partnership or LLP, the rights and obligation of parties, which by their nature or express terms are intended to survive. Because we have talked about the liability, post exit liability, rights and obligation of the parties. Okay, so even they exit from the party, partnership firm or LLPs still exists. So post their exit also, this will survive. So this survival clause talks about survival of their rights and obligations post their exit. Okay, such provisions shall include but not limited to confidentiality obligations. There will be non-compete and non-solicitation commitments, indemnity provisions, liability for acts or omission occurring prior to termination, and dispute resolution mechanism. So suppose post exit, if he enters into dispute with respect to anything which has occurred during his tenure, then also he has to follow this dispute resolution mechanism. He cannot say, I am the outgoing partner, now I will not follow mediation arbitration, I will directly go to the court. Therefore, this survival clause is very much important to protect the interest of partnership and existing the parties. For PDFs, we can define the period that so many years it will be effective, or as otherwise specified in this agreement or required by the applicable law. So this is also important survival clause. Now there are miscellaneous clauses. Since we have time 15 minutes, we will quickly cover common miscellaneous clauses. So this is like entire agreement. This agreement, be it a partnership, be it LLP, be it so many agreements, you can use this clause that this agreement constitutes the entire understanding between the parties and supersedes all prior discussion, negotiation agreements, whether oral or written or relating to the subject matter herein. Next, amendments. No modification, amendment, or waiver of any provision of this agreement shall be valid unless made in writing or signed by all parties. In case of an LLP, such amendment shall also be filed with the registrar. So only difference is when it is a partnership, normal partnership under Partnership Act, if it is registered one, then you have to comply. LLP is always registered one. So whenever LLP agreement, any changes, any amendment, you have to mandatorily file with the registrar. Severability. If any provision of this provision of this agreement is held invalid, illegal, or unenforceable, the remaining provision shall continue in full force and effect without being impaired in any way. Force majeure. No party shall be liable for any failure or delay in performing their obligation under this agreement if such failure or delay results from events beyond their reasonable control, including but not limited to natural disaster, war, governmental actions, strikes, or pandemics. Now, This clause is common both in LLP as well as partnership agreement, and in any other agreement also you can include this clause. Waiver. Failure or delay by any party in exercising any right, power, or privilege under this agreement shall not operate as a waiver thereof, nor shall any single or partial exercise of such right preclude any other or further exercise thereof. Like if I am silent, if I am not exercising my power or privilege, that doesn't mean I have waived off my right. Now, this is very important because this agreement shall be governed by and construed in accordance with the law of India. You can also mention Partnership Act or LLP Act, as the case may be. Subject to the arbitration clause herein, the courts at so and so shall have exclusive jurisdiction over dispute arising out of this agreement. So why arbitral award is the final one? Why court is there? Because to enforce this also and to challenge also, you have to have jurisdiction point in this agreement. Again, this jurisdiction point can be common in partnership and LLP. Now, this is the optional clause. This agreement may be executed in multiple counterparts, each of which shall be deemed an original, and all of which together shall constitute one and the same instrument. There are cases when all partners want the original agreement. Then you can always put this clause and execute multiple agreements. Signature and witness clause common in all the agreements, that this should be like this. Now, some important notes. At least two witnesses are advisable for enforceability in this agreement. For LLP, after signing the after signing the agreement, LLP agreement, you should file it with the registrar within 30 days, along with the LLP form 3. And stamp duty should be paid as per the applicable state laws. You have to check again which state you will check as per the jurisdiction. In partnership agreement, jurisdiction of principal place of business. In LLP, registered office of the LLP. You can decide where, in which state your registered office the LLP is. You can accordingly you can decide the stamp duty as well as the register of jurisdiction of the register. So with this, we will conclude this session. Uh,
Thank you so much, sir. Now we open the floor for question and answers. Whosoever have any questions, you can ask your questions directly from sir or can raise your hands.
so in chat,
Anybody have questions? So there's been question in the chat box. LLP allows capital in the forms of intangibles where a partner exists. Will he have rights over the intangible, say IP, brought in at the beginning, say a patent?
like LLP allows capital in the form of intangibles where a partner exits will have rights over the intangible, say IP brought in at the beginning, say a patent. So for example, you in the form of contribution you are bringing some IP. Like if I have some intellectual property, I am bringing into the business. So at the time of entering also we can decide that whether at the time of exit it will remain with me or not. But preferably all the LLP, what they will do when partner exits from the LLP or retires from the LLP, who has brought the IP, it will be he will be compensated according to the value of the IP. Therefore, I have mentioned that valuation of the capital is must when you are bringing any thing monetary, intangible, tangible, or services. Then valuation is must when you are bringing in, so that at the time of exit, valuation as per the goodwill also partner may be compensated. But all the partner can decide if they want to give the IP rights to the partner, outgoing partner. Okay, so any other question?
So partnership deed shall be
Partnership deed
registered,
is
but
registered, but registration at register as firm is optional. Yes, partnership deed shall be registered, but registration at register as firm is optional. So, uh, partnership deed should be registered. So, you mean to say deed should be registered, but registration of firm is not is optional? No, no, no. How you will register the firm? If you are talking that you will take the partnership deed and take it notarized and consider it registered, then it is your understanding. But registration of firm will happen with the registration of deed only. How will register the firm? So it is optional, correct? In the Maharashtra, it is optional, but it is always advisable also to register the firm, because whenever you initiate a legal case, they will ask for the registered firm. You cannot sue without the firm is registered, because unregistered firm cannot sue anyone, but it can be sued by anyone. Hope you understand. Very well prepared PPT. Okay, extremely insightful. Okay, any more question?
thank you so much, sir, for this wonderful session.
We have more 6 minutes. If any question, you can put in the chat box.
Thank you so much, sir, for this wonderful session. And on behalf of the organizing committee, I extend a sincere gratitude to you, sir, not only for accepting our invitation, but also for such a thoughtful and enriching session today. We are truly thankful to you, sir. Thank you so much, sir, and thank you all the participants for joining.
Thank you all.